Diplomacy and International Relations, dated 12th of March 2015, from the same university. As a respondent, I need first to address several objections that were raised by Mr. Mashari. The first challenge was that this court lacks jurisdiction to deal with the issue of the first respondents. Article 88(4)(e) of the Constitution and Section 74(1) of the Elections Act provide to the effect that it is the Commission, elections and disputes subsequent to the declaration of election results, quote. In the Jared Odoyo case issue before the election court, that the petitioner should have challenged the decision before the High Court and not the election court. It is the decision of that committee in this forum. Mr. Mwanza referred the court to the decision of the Supreme Court in support governor and sections 22(2) and 75 of the Elections Act, which provides for qualification of governors and county election petitions. Section 75 of the Elections Act provides, quote, dictionary 12th edition, the term election is defined as a form of procedure when election is defined as the process of selecting a person to occupy an office. While this was Encyclopedia Law Dictionary, also been subject to judicial pronouncements. In the state of Karamataka versus Gunjarari Nagapa, the court by which an elected member is returned, whether or not it is found necessary to take a poll. In Raila 2 case, the Supreme Court of Kenya held, quote, neither Article 88(4) nor Section 74 of the Elections Act precludes the election court from determining whether the election for Wajir governor was valid or not. Accordingly, that objection is rejected. The second objection was that the issue of eligibility or qualification of a candidate is the responsibility of the Commission and not this court. The case of Michael Wajir and Derito and others versus Mary Wamboi Munene was cited in support of the contention. The decision in Michael Wajir's case is not applicable. In that case, the court was not considering a question of validity of an election, but it was a constitutional petition as to whether an aspirant was eligible to run for position of member of National Assembly. In the present case, the petition seeks to question the validity of the election of the first respondent under Section 75 of the Elections Act. One of the issues that have been raised in that petition for determination is whether he was qualified in law to vie for that position. The fact that the Commission has that responsibility does not in itself preclude the election code from satisfying itself that a candidate was eligible to stand for election when the issue arises, as it has in this case. This now paves the way for me to consider the issue of whether or not the first respondent was legally qualified to vie for the governor's seat. As earlier stated, 2 certificates of degrees were produced, a bachelor's degree in business administration and a master's degree in diplomacy and international relations. They are from a university recognized in Kenya via the letter of recognition dated 11th January 2013 from the Commission of Higher Education. The petitioners contended that the bachelor's degree dated 1st of March 2012 was not genuine. PW1 swore that the first respondent could not enroll in any university as he had neither sat for O-level nor A-level examinations. He also swore that the first respondent did not appear in the list of graduates for the graduation of 1st of March 2012 for Kampala University. He produced the graduation booklet as AMM A6. He further testified that the first respondent had admitted during his vetting for position of ambassador to Riyadh before the Departmental Committee on Defense and Foreign Relations on 3rd of September 2014 that he had not acquired a degree. PW1 produced the minutes of that committee as AMMA7. He stood firm on that testimony despite intense cross-examination. On the other hand, the first respondent did not specifically deny in his replying affidavit any of these allegations. He only stated that the issue had been litigated in the Ugandan High Court and dismissed. Further, he failed to turn up for cross-examination on his said affidavit at the trial. Of not having had a degree by 2014, Uganda was dismissed on a technicality, that is, for lack of authority to the third issue, whether the first respondent was validly elected as governor of Wajir County. The principles set out in Articles 81 and 86 of the Constitution are to the effect that the electoral process must be accurately and competently conducted. The election should have a proper and verifiable record made on prescribed forms and executed by the relevant authorized election officials. An accountable election whose record is capable of being audited. That the sanctity of the secrecy of ballot should be jealously upheld in order to maintain the free will of the people when exercising their sovereign will by choosing those they wish to surrender their power to rule over them. An election must reflect the people's free will through credibility, verifiability, efficiency, and accuracy. An election court should always strive to secure and retain the will of the people. Mere irregularities in the conduct of an election that do not affect the results cannot by themselves invalidate an election. Same with procedural and administrative irregularities and other errors occasioned by human imperfection. See the cases of Evans, Odhiambo Odero, Kidero, and Masi Kirito Mutegi. No election can be perfect without any errors. Elections are not perfect, and not all malpractices will lead to nullification of the results. That is what Section 83 of the Elections Act is apt about. Our own Supreme Court held in Raila 2 that at the outset, we must re-emphasize the fact that not every irregularity, not every infraction of the law is enough to nullify an election. Were it to be so, there would hardly be any election in this country, if not the world, that would withstand judicial scrutiny. The correct approach, therefore, is for a court of law to not only determine whether the election was characterized by irregularities, but whether those irregularities were of such a nature or such a magnitude as to have either affected the result of the election or to have so negatively impacted on the integrity of the election that no reasonable tribunal would uphold it. The court then stated of Section 83 as follows, quote, quote, in our respective view, the two limbs of Section 83 of the Elections Act should be applied disjunctively. In the circumstances, a petitioner who is able to satisfactorily prove either of the two limbs of the section can void an election. In other words, a petitioner who is able to prove that the conduct of the election in question substantially violated the principles laid down in our Constitution, as well as other written law on elections, will on that ground alone void an election. He will also be able to void an election if he is able to prove that although the election was conducted substantially in accordance with the principles laid down in our Constitution, as well as other written law on election, it was fraught with irregularities or illegalities that affected the result of the election, quote, quote. The resident of Wajir County, who woke up early on the 8th of August 2017, armed with the promise of the Constitution, traveled a long distance to reach the polling station where he was registered, queued the whole day with the hope that he would cast his vote in secret. That after casting his vote, it would count, and that in the event of an audit, it will be verifiable. The aspirations of Kenyans are embedded in the Constitution of Kenya 2010. Those aspirations were not intended to remain as just that. They were intended and are expected to be a reality, that every Kenyan should live them. It is only then that the citizens of this country will feel settled. It is for that reason that every individual, as well as institution, charged with the realization of the principles contained in the Constitution, must strive to achieve them. These include the principles of a free and fair election as set out in Articles 81 and 86 of the Constitution. Anything short of that is unacceptable, and the courts will compel compliance therewith. In the present case, the court has found that the principle of the secrecy of the ballot was breached. The record of the election through the prescribed forms 37A, 37B, and 37C was neither accountable nor credible. That because of the irregularities committed by the second and third respondent, the elections could not be verified. From the irregularities committed, the third respondent cannot be said to have conducted the elections competently and efficiently. It employed election officials who were incompetent or negligent and whose conduct made the elections unaccountable and unverifiable. Accordingly, this court holds that the election of Wajir County for the governor's seat was not conducted in accordance with the Constitution and the law. The totality of the irregularities proved affected the results of the election. It follows, therefore, that the first respondent was not validly elected as the governor of Wajir County. As to costs, the parties did not address me on it, I will award the costs to the petitioners. However, since the claim and award of costs in election petitions has hitherto been erratic, I will cap instructions fees at 2 million shillings. Ordinarily, it is the guilty party to bear the costs. In this case, not only has the court found the election officials guilty of the irregularities that affected the election, the first respondent has also been found to be culpable. He presented himself to the second and third respondent to be cleared as a candidate, yet he was not legally qualified to vie for the seat of governor. Accordingly, the costs will be shared by the respondents. Final declarations.
Said that what happened in Wajir County on the 8th of August with respect to the gubernatorial election is a manifestation of everything that has gone wrong in the electoral process in this country. Where an unqualified candidate is clear to run and the election rigged in their favor. So we want to ask our people to be humble, thanks. Going through this court process has not been easy for us. Thank you. Because a lot of our people do not believe in going to court to seek justice. We were told to forget and move on. We said no. For their sake, we will seek justice.
Yes.
And it's been served today. We want to ask our supporters to celebrate in humility, and we want to assure the people of Wajir in due course we'll get back to them, and what they have been robbed of on the 8th of August will, by the will of God, be returned to them. Thank you very much.
Okay, Santini.
Thank you. Thank you. One of the petitioners, I say in brief that this was victory for justice and the great people of Wajir County, as I've said. We have decided on the very onset, after the declaration was made, that the elections as had happened in Wajir County on 8/8/17 was shambolic. It didn't conform to the requirements of law. It didn't conform to the wishes of the great people of Wajir County. It was a real subversion of the will of the people of Wajir County. That we were vindicated today by the courts is a justification that our beliefs were right. Our beliefs were right. We believed in justice. And here we are today, we have justice. Justice for the people of Kenya, justice specifically for the people of Wajir County, whether within the country or outside the country. To that extent, we send specific thanks and tribute to our supporters who have been with us through all the hardships.